Okay, Attorney Nate Amendola here, criminal defense, criminal law in plain English. The question or topic today is what to do about false allegations or false accusations. There are, of course, cases where the accusations aren't false and are true. And we'll talk about how to defend cases like that. Um, and there are, of course, cases where there's plenty of false accusations. The whole thing is made up. And then there's sort of these cases that are in between that involve some sort of falsehood, but also maybe some truth. For example, there's been some sort of fight. The defendant or the accused doesn't dispute the fight, but disputes why the fight started. And maybe it was some other person was the initial aggressor, or there was a self-defense claim. That's not what we're here to talk about today. Today, the topic really is false allegations or accusations. We typically see these in three. Of course, this changes, and there's lots of exceptions to this, but generally speaking, you really see them in essentially three different types of cases. The first is a sexual assault case where there's been some allegation of sexual misconduct. The second is cases that involve allegations of domestic violence. Here in Massachusetts, there's no crime called domestic violence. It's called assault and battery on a household member, but everybody calls it domestic violence. And then the third type of false allegation we see a lot. Well, I should say also some other assault and batteries, and then sort of these child abuse type of cases. So again, these cases we're strictly talking about when there's really, well, what I should say is somebody will often say, there's no evidence against me. How can the prosecutor move forward? There's absolutely no evidence. And a lot of times that is true with respect to physical evidence. Okay? Things like a video or a recorded call, forget the wiretap statute for a second, an eyewitness, a scientific result, a DNA test, a rape kit, whatever it may be. Folks often say, well, there's absolutely no evidence against me. No, that is not true. Somebody's statement or somebody's word, or think about it like this, somebody's testimony in court about what happened to them or what purportedly happened to them, that's competent evidence. Assuming there's, doesn't run afoul of any of the rules of evidence, somebody's statement about what happened to them is evidence. Oral testimony is evidence. So yes, he said, she said cases are very real, they're very common, and they can go forward because somebody is saying something happened, and that's all certainly would satisfy often the probable cause requirement. We've talked a lot about that. Whether or not it satisfies the reasonable doubt calculus, I don't know. We're not here to talk about that today. But again, it's just it is somebody's word is evidence. Okay, so I think that's the first thing you've got to understand. So when you've been falsely accused or there's false allegations, there's three things that I want you to think about. Okay, so the first one we're going to talk about an acronym, MIT. I'm here in Massachusetts. That acronym does not stand for Massachusetts Institute of Technology in this context, but rather it stands for motive to lie, inconsistent statements, and triggering event. I learned this from my great friend and legendary criminal defense lawyer here in Massachusetts, Ted Barone. So let's talk about the M, motive to lie. In these types of cases, particularly sexual assaults, domestic violence, things like that, you've got to figure out why this person is lying. Okay? People lie all the time for lots of different reasons. And part of figuring out your defense, perhaps the biggest part about figuring out your defense in these types of cases, is figuring out what somebody's motivation to lie is. Okay? So there's lots of these. We can just think of a couple right now. With a sexual assault, maybe the accuser is in a relationship and is cheating on their significant other, and their significant other has found out, and they're saying that they didn't consent, they were drunk, or there was an attack, or whatever it may be. And of course, some of these are very real, but sometimes they're not. Um, so that's perhaps a motive to lie in these domestic violence cases. Again, some of these are very real, but the ones that are fabricated, sometimes maybe there's a child custody dispute or there's a divorce going on. Divorce is a big one, and the accuser is making these false allegations to gain some advantage or to leverage the divorce process or the probate process or the child custody process. And the same thing goes with maybe like a child abuse case where the child is saying that there's been some sort of neglect or misconduct or whatever the case may be, and maybe they're being manipulated by another parent, or maybe they're in trouble at school, and they're using this. Mom and dad are mad at them, and then all of a sudden they're making a disclosure of God forbid sexual misconduct or something else, and it sort of takes the focus off of their malfeasance, so to speak, at school or somewhere else. All right. I stands for inconsistent statement or statements or conduct. So when you think about this, how can you help your lawyer identify sort of this inconsistent conduct with somebody who has been abused, right? Are there pictures right after the alleged event? Are there text messages that have happened after the alleged event that are just totally inconsistent with somebody who's been abused or something like that? Inconsistent statements, if an alleged victim has made multiple statements to police, maybe what's called a SANE or a forensic interview, where they're talking to trained professionals on what allegedly happened to them. Are there inconsistent statements between each of those recorded events? Obviously, people who are not telling the truth, their stories, I think everybody knows this, their stories change over time, or any major inconsistencies really can show somebody that they're lying. By the way, in court, I don't use the word, or I very rarely use the word lying. I think that's a difficult thing to say in a court, especially at a closing argument when the victim's behind you. But I think the better way to say it is mendacious. Mendacious is when somebody that's the sort of a euphemism. Well, it's another way of saying lying, right? And I think that's just a little gentler, and I think it sounds a little bit more professional. Definitely not everybody agrees with me. This is just my take on things. All right. And then T stands for triggering event. This is also important. You got to figure out what is the triggering event that caused this person to make the disclosure. Who knows what it is, right? I mean, but you've got to develop that. Maybe there's, again, like a divorce. Maybe that was the triggering event. It could be the same as the motive to lie. Oftentimes they're connected or related, all right? The second thing you can do is take affirmative action in your case. Right? So obviously you're going to be working with your lawyers or lawyer on going through the discovery and developing a competent and cogent theory of defense. But you should also, if you've got some domestic violence charge, even though it's false, your lawyer may suggest you take some online classes or some therapy. I don't want to have anybody do something that they feel is a waste of time. But as lawyers, we really think that you got to attack cases from a bunch of different angles. And one of them is you're not admitting guilt by doing any of this stuff. And maybe your lawyer doesn't even tell the prosecutor or the court that it's being done. But if you're taking affirmative steps to look like you're addressing the problem or something, that's just frankly going to do nothing but help you. I think a lot of people really miss this, and they just sort of sit idly by. They're helping their attorneys or whatnot, but they're not taking these affirmative steps. If it's a case that involves drugs or alcohol, particularly drugs, minor drug possession, sometimes possession with intent to distribute. I think if you're a first timer, that is ripe for going to drug and alcohol treatment, sometimes inpatient, sometimes outpatient. Get a substance abuse eval. That can be courts really like this stuff. Everybody likes a redemption story. So that's a little different than a false accusation here, but just do what you're supposed to be doing, because sometimes the goal here, generally speaking, is to get these dismissed prior to trial. There's certainly some folks that want to go to trial and show their innocence, but there's lots of folks, particularly the ones we represent, who've never been in trouble before, and that's a significant risk. And so there's lots of different ways to hedge against that risk. This is one of them. Do what you're supposed to be doing. All right. And the third is, we've talked a lot about this, or I've talked a lot about this. Don't talk to the police or an investigator. I am not making any negative statements about law enforcement, but they are there for one thing. They're there to investigate a crime. So if your accuser is saying that you did this misdeed or whatever the misconduct was, and the police come talk to you, there's no doubt you want to protest your innocence. I didn't do that. I didn't do that. Here's my version of the facts. Number one, statements of "I didn't do that," "that wasn't me," "that didn't happen," are generally inadmissible in court for a defendant's case. All right. So just denying the crime is not going to help you. Right. Staying silent is. All right. And then giving your side of the story is this, you're essentially giving testimony. Your statements. We've talked a lot about this. You have a Fifth Amendment right to remain silent. I've written about this. I've talked about this. Use it. Do not say anything. The police come and ask you some questions. You can very politely say, "Thank you, Mr. Police Officer. I appreciate you being here, but I'm not going to talk to you about that." Okay? That's all you got to do. And I guess now there's four things I'm saying. And the fourth thing is you got to be ready for trial. Okay? So even if your identified goal is to get the case dismissed or to have a mitigation strategy, keep me out of jail, whatever it is, it really doesn't matter. You should be preparing every case like it's going to trial. You've got to do that in parallel with whatever else that you're doing, the other couple items that I've talked about. This is important for a bunch of different reasons. Again, back to my friend Ted Barone, who said a criminal case is like fine wine. It gets better with age. That's hard for everybody who's been accused of a crime. But generally speaking, this is not always true, but generally speaking, the longer a case goes on, the better for a defendant. People move, accusers move away, accusers get busy, accusers careless about the crime, the purported crime. The prosecutors, right on when the case starts, it might be their first file that they see, and everyone's excited to litigate the case, but then over time it gets lower and lower and lower on their deck. Sometimes the prosecutor hasn't met with the alleged victim yet, and as it gets closer to trial, they'll be interviewed and they'll prepare for the trial. And the prosecutor, if they're good, bold, and they've are prosecuting ethically, they may say, "Look, this alleged victim's got some problems. She's not credible," or whatever the issue may be. And maybe then, after trial prep and after you show the court, the prosecutor, that you're ready to try the case falls apart. So being falsely accused is really difficult. People immediately want to defend themselves. That's what lawyers are for. But there are definitely things you can do. You should not sit and be passive in your case. Again, I'm Nate Amendola, criminal law in plain English.